Thank you, ladies and gentlemen. You've been waiting patiently. I'm sorry to the extent that my difficulty getting out of Washington and into Charlottesville was the cause of it. When I arrived at the Omni downtown, there was a little note of welcoming me to our charming city, and I couldn't help thinking that I really could welcome the Omni rather than the Omni welcoming me. I taught here for 4 years full time, and as was just mentioned, as one of UVA's weekend warriors for several years when I was on the Court of Appeals and elsewhere in the government for that matter. And I could have told the Omni that sometimes the electricity does go off in Charlottesville for an hour, and any sensible person has a hurricane lamp. But, those of you who are staying at the Omni will know what I mean. The topic of the first panel this evening is there an unwritten constitution? The reason I was a little late getting here and couldn't leave any earlier was that Friday is conference day at the court, and I was engaged in the process of helping to write the unwritten constitution. The question, of course, is an interesting one. It's customary for the moderator of a panel, whose main function consists of keeping order, nonetheless to make a few comments about the topic, so that the speakers will know what it is that their remarks are departing from. It seems to me that in one sense the question is a very easy one. In one sense, the answer to the question, is there an unwritten constitution, is of course not. No one in no court, no judge, in applying what purports to be a principle of constitutional law or of any type of law that overrides the doings of the legislature or the executive appeals to anything except the written constitution. And indeed, if he didn't appeal to it, you would not know what constitution he was departing from, whether it was the federal constitution or the state constitution. So in one sense, we all agree that it is a written constitution that governs us all, both at the state and the federal level. And the question is easy to answer in another sense. In another sense, the easy answer to the question, is there an unwritten constitution, is, of course, there is an unwritten constitution. That is to say, many of the provisions, perhaps most of the provisions of the Constitution do not make sense except as they are given meaning by the historical background in which they were adopted. The phrase due process of law means something quite different to a 16th century Tahitian from what it would have meant to an 18th century American. One does not know what it means to be deprived of life, liberty, or property without due process of law, without knowing, for example, what the word property meant. So in that sense, it's easy to say, of course, there is an unwritten constitution. That is to say, a whole history of meaning to the words that the Constitution contains, and without which history the Constitution is meaningless. Nonetheless, it will neither surprise nor disappoint you to know that the question does have some controversy associated with it. And I suppose, this is my guess, that what we will mainly hear discussed this evening is the question of, first of all, the Ninth Amendment, just in case there may be undergraduates or even first-year law students here. If someone had asked me when I was in law school, or even in the first few years of my practice, quick, what is the Ninth Amendment? I would not have had the slightest idea. I mean, I know the First, I know the Fifth, I know the Sixth, the Eighth, the Ninth Amendment. I think one can be grateful for Judge Bork's hearings for the fact that they brought the Ninth Amendment to new prominence in, although I expect many of those watching the hearings didn't have the slightest idea what the controversy was. So for those of you who haven't been reading the Constitution recently, the Ninth Amendment says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the controversy, in part, is about that amendment, whether it imports into the Constitution a whole body, a constellation of other unwritten provisions that are the rights retained by the people. And the controversy is about similar provisions in the Constitution, although perhaps not as broad on their face, but which could be interpreted in a somewhat similar way, such as the Privileges and Immunities Clause and the Due Process Clause. To what extent do these import into the Constitution guarantees of a less specific nature than those that are there explicitly set forth? When they are imported, where do they come from? Do they come purely from history? Do they come from philosophy, the natural rights of man? Or perhaps do they come from an evolving consensus of the society? Those, I think, are the main alternatives. It's a good topic for this organization. Many people have the impression that the Federalist Society is a very homogeneous group. Those who know it well realize, of course, that it is a strange amalgam of libertarians and Burkean conservatives. That's Burkean with a U, not an O. With that as prologue, I will proceed to the introduction of our speakers. And I don't know whether they prefer to talk from here or from there. I came up here only because I was the only one up here when I arrived. Whichever you like.
I'd rather stay.
Stay from there? Yes, we'll do it right from down there. I have first to announce that regrettably Professor Ellen Frankel Paul, because of illness, has been unable to come. So we will go with a panel of three. The first of whom is Professor Paul Bator. Professor Bator is the John P. Wilson Professor of Law at the University of Chicago. He completed his undergraduate education at Princeton, then studied history as a Woodrow Wilson Fellow at Harvard. He graduated from Harvard Law School in 1956, having served as president of the Harvard Law Review, and served as a law clerk to Justice John Harlan. He later joined the Harvard faculty and was associate dean from 1971 to 75. In 1983, he was appointed Deputy Solicitor General and Counselor to the Solicitor General of the United States. Professor Bator began teaching at the University of Chicago in 1986. He is, those of you who are law students know, a co-editor of the widely adopted text, Hart and Wexler's The Federal Courts and the Federal System. Professor Bator.
Thank you very much. It's a great pleasure to be back at this is my seventh, I think my attendance record is perfect, my seventh straight attendance at these annual symposiums, which have, for many of us, come to be a source of enormous intellectual stimulation and also a happy family party. So it's very, very nice to be here, and very nice and appropriate that it should be, the host this year should be the University of Virginia Law School. Our question is there, for tonight's panel, is there an unwritten constitution? Am I talking about the right loudness, too loud, or, okay? Is there an unwritten constitution? The question is one whose exquisite ambiguity puts me in mind of one of the most subtly Jamesian jokes that was invented by that most subtly Jamesian of my former colleagues at Harvard Law School, Paul Freund, who once, I think it was his invention, put the story of the bishop of the Episcopal Church who was approached by a parishioner out of breath and excited, who said, "Bishop, Bishop, you must explain to me what is the difference between the seraphim and the cherubim." And the bishop pondered the question. He said, "The difference between the seraphim and the cherubim have all been composed, and all is well." I have a faint sense that the ambiguity of the question, is there an unwritten constitution, is actually going to haunt and probably somewhat confuse the entire proceedings of this symposium, because you can't think intelligently of whether there is an unwritten constitution without having a theory about what you mean by a written constitution. That is to say, the very question of what is encompassed by the writing and how we define the dividing line between what is encompassed in the writing and what is outside it itself is not a simple question. It's not an empirical question. It's a question about which you have to have a theory of language and a theory about law. It seems to me clear that if what we mean by a written constitution is a theory about a narrow, literal, strict construction which limits the language to the narrowest confines in which it can be put, if that is what is meant by a written constitution, it seems to me a trivial point that, of course, in that case there must be, and there should be an unwritten constitution. That is to say that the project, you cannot combine the project of saying that it is illegitimate to have an unwritten constitution with a project that also includes a narrow or strict or literal interpretation of the words. The reason for that is not only the well-known conventional one that when one is drafting the words, one cannot, the drafters of the document cannot foresee all of the issues of application that may arise. There are really far deeper reasons. There are reasons that Justice Scalia has already touched on. There are reasons deriving from the nature of language and from the epistemology of knowledge. The fact is that no text can specify all of its meanings. Every provision, every statement, every use of language is inherently and of necessity both over-inclusive and under-inclusive. That is to say, it cannot specify exactly all of the applications and issues which may arise with respect to its interpretation. The point about that is not only that the drafter would find it an exhausting task and it would be incredibly long to try to write out all the specifying meanings, but the point again is somewhat deeper, that we do not actually encompass in a literal sense, we do not know all of the meanings that we have, although we actually do have them. Many of the meanings that we intend to convey, and these are real meanings, these are not indeterminacies, are shorthanded by language and are elided by the thought processes that lead to language or taken for granted in terms of the background understandings within which language has to operate. And that is especially the case with legal language, whose operational consequences are not static but dynamic. That is to say, legal texts, legal provisions, constitutional provisions and statutes are meant to be embodied in an ongoing enterprise of social governance. And the adjustment of that enterprise to other and pre-existing human enterprises cannot be specified exactly by the language. That's true of spoken words, it's true of written words. Written words, like spoken words, have a body language. And if you don't understand the body language, if you don't understand the music of the word, you will not have any sense of its meanings. The text must be placed in the context of all sorts of historical and linguistic practices and understandings in order for it to be intelligible. Now, the fact that we cannot specify all of the meanings that we have when we communicate through a constitution or a statute does not mean, and is not the equivalent of saying that the language is indeterminate. I think that one of the most mischievous and confusing formulas that has been invented is that all language is indeterminate. It's a dangerous folly to think that the failure of language to specify all of its meaning is the same as saying that the language has no meaning and that it's completely up for grabs. The Constitution is full of entirely determinate, albeit not specified, content. That is the secret, I think, of the art of good interpretation. And if that is all we mean by an unwritten Constitution, it seems to me that we have not done any great mischief. I'll give two examples of that. One is, I think, uncontroversial, and the other one is, at least in the wider legal terrain, would be considered very controversial. It's entirely uncontroversial that the First Amendment is both over-inclusive and under-inclusive in its text. It's over-inclusive in the sense that we all now know that no cannot mean no law, that there are all kinds of background understandings within which some legislation respecting speech or freedom of speech must be allowed. It is under-inclusive in the sense that, at least to some extent, we know that the very concept of speech and what it encompasses, what counts as speech, is a term that has ambiguity and that requires interpretation. There is no way of understanding the First Amendment that tries to seek some kind of a Platonic or a strict textual boundary for those terms. You have to understand the body language of the amendment. My more controversial example comes from the 11th Amendment, which is a problematic and interesting provision. The 11th Amendment passed in reaction to a wrong-headed Supreme Court opinion, not the last, called Chisholm in Georgia, which said that the states can be sued in a federal court on their bonds for damages, says that the judicial power shall not extend to, and then it has some very narrow technical specific language, to controversies between a state and a citizen of another state. Fairly early in its history, this language was interpreted by the court as a shorthand for a much more encompassing proposition, which was that in the absence of consent, the states may not be sued for damages, whether it's by a citizen of another state or anybody else. That there is no damage action in the federal courts against the states without consent. By the way, the without consent is the example in which is the example of how the 11th Amendment is over-inclusive, because the amendment doesn't say that the judicial power does extend if the state consents. Again, here you have to turn to the background understanding of what sovereign immunity was meant to be about. And the court had no difficulty quite correctly coming to the conclusion that if the state consents, the judicial power does extend, even to the textually covered case of the out-of-state citizens. In view of the narrowness of the text, Justice Brennan, now unhappily having been joined by at least 2 or maybe 3 others, is now conducting a campaign to what he calls returning the 11th Amendment to its historic meaning, that is to say, to cover only the cases specified in the text, that is, cases brought by out-of-state citizens, and thereby excluding the coverage of the 11th Amendment from any case brought under some other jurisdictional heading, primarily cases brought to enforce federal law. The position is that the 11th Amendment doesn't say, and therefore should not be interpreted, to extend to any case where the plaintiff is seeking to enforce the federal constitution or a federal statute. Now, my assertion or my submission is that it would be absolutely scandalous for the court to adopt that revisionist view, because it would be an example of not understanding what I call the body language or the hidden meaning, the determinate though unspecified meaning of the amendment. And here is my reasoning on that. The purpose of the 11th Amendment was to override a judicial opinion which allowed the judges to create common law actions against the states without their consent. That is what created the constitutional crisis that led to the 11th Amendment. At the time that crisis arose, what was meant by the conception of a common law action created by the judges against the state? What was meant was the only kind of common law that then existed, which was the ordinary common law of the states, enforced by the courts. And therefore, the only problem which was visible on the horizon in the creation of damage actions at common law by the judges was state-created damage actions which were in the federal courts only because of the diverse citizenship that the constitutional provision specified. Do you see? The specification of the diversity jurisdiction as the basis of the problem was a shorthand reflecting the political understanding that that is the best way to say to the judges, common law liabilities against the states may not be enforced by the judges without consent. Now, in the last 50 years, we have developed a huge body of law, an absolutely Baroque body of law that allows the federal judges in the name of the federal common law, under the guise of either implied statutory causes of action or so-called implied constitutional actions to impose damage liabilities on government officials. And the submission, you see, the revisionist submission is that because the Constitution doesn't specify these cases of federal common law liability, therefore we should read the amendment as not covering those cases. My counter-submission is that it would be scandalous. It would be like saying the Fourth Amendment doesn't deal with electronic eavesdropping or something like that, because that didn't exist. Federal common law implied and constitutional actions imposing damages didn't exist. And if we did that, we would be doing exactly what the framers of the 11th Amendment, in a political sense, were designing to do. It's not understanding the music of the constitutional provision. So that seems to me an example of a case where it is absolutely imperative. We would have an incoherent constitution, an anti-constitutional constitution, if we fully respected both the over-inclusions and the under-inclusions of constitutional provisions, which are not indeterminate, they are simply unspecified. And the art of interpretation is to find the unspecified, although wholly determinate, purposive underlying function of the provision. So that is my principal conclusion here tonight, that yes, we must have an unwritten constitution in the sense of discovering the unspecified provisions of the text. The project of a strict interpretation is a doomed project and would lead to an anti-constitutional constitution. It's important politically for the conservative movement and the law to understand also that an attack on unrestrained judicial subjectivism does not necessarily put you in the camp of an unsophisticated group of people who say that a strict or literal construction is the only alternative. That is to say, we must understand that the alternative to judicial subjectivism is not the simplistic and naive notion of a strict or crabbed construction. Now, the more difficult question on which I will punt is whether there should or is an unwritten constitution in any other sense. That is where the Constitution really is indeterminate. Although here again, I think it would be useful to draw a distinction Sometimes what is meant by indeterminacy, although substantively controversial, ought to be methodologically entirely uncontroversial. It is where there is a genuine ambiguity. That is to say, there is no issue as to the coverage of the Constitution, but there is a genuine ambiguity about which way the substance of the provision points. And it seems to me that is a methodologically unproblematic example, if that is an example at all, of the so-called unwritten Constitution. It seems to me the real problems arise are in the boundary areas where the issue of indeterminacy really relates to the question of coverage. Does the Constitution speak to the subject at all? Is it ever legitimate for the judges or the justices to drive the Constitution into areas where neither the explicit nor the unspecified meaning of the Constitution puts you? That is to say, can you use the Constitution in a common law method? Can you drive the Constitution by the methods of the common law to areas which fairly are not covered at all? And we have analogous problems under statutes. There is a divergence in the law as to the legitimacy of using statutes as a source of law. The implied right of action controversy is only one example of this. Do you use the statute as an engine to create new law? On this one, it's really, I think, going to be the dominant theme of the remaining proceedings. It seems to me essential here that we try to organize the inquiry in terms of finding some legitimate, what might be called meta-rules about the Constitution. That is, we need to develop some canons of construction and other sort of moral and structural postulates that help fit the Constitution and the role of the judges under the Constitution into the surrounding fabric of the law. For me, and I won't flog this horse, I've done it at enough of these meetings, a major postulate here that is a great claim for primacy is the postulate of judicial restraint. What I want to point out, in a sense, though, is that oddly enough, the Constitution itself in its text seems to have two of these meta-rules, rules of construction about how to fit the Constitution into the surrounding framework. And those, of course, are the 9th Amendment and the 10th Amendment. Is it the 9th and the 10th, or the 10th and the 11th?
The 9th and the 10th.
The 9th and the 10th. The 9th is the unenumerated rights.
The 11th
It's shocking that I don't know, but it would have been even more shocking if he didn't.
Well, I don't know what he's referring to. I mean, you didn't show me your speech beforehand, Paul. I mean,
the 9th and the 10th Amendments, which really ought to be read together. That is, it's one of the oddities of the recent debate, is that there is all this talk about the 9th Amendment and the problem of unenumerated rights. And no discussion of the Twin Amendment, which says that the powers not specified to the federal government by this document are reserved to the people and to the states. These two meta-rules of constitutional interpretation seem to me to stand in considerable tension, and it seems to me that one of the challenges here is to see whether order can be organized out of that tension. It is part of my, and this is a kind of a subversive point I want to make here, but one of the points I think we ought to remember when we're thinking about the 10th Amendment is that I think the Supreme Court and the federal courts count as part of the federal power for purposes of what is reserved to the people and what is reserved to the states under the 10th Amendment. That is to say, when the Constitution says that unspecified powers are not given to the federal government, that seems to me to include the federal courts. Because if there is one thing that is clear in the history of the making of the Constitution, is that the judicial power, the federal judicial power, was regarded very much as a center of the problem of how much federal power there should be overall. That is, there was no sense that the federal judicial power somehow stood outside of the allocation of powers as between federal government and states. It was very much conceived of as within the scope of the substantive federal judicial power that was to be given. The Ninth Amendment obviously is problematic, but it would be a major anachronism at this point to read the Ninth Amendment without looking at the 10th as an open-ended charter to the judges to create unspecified and wholly indeterminate rights from the Constitution. It's not only that it's very dubious whether the Ninth Amendment was directed at the states in any event, that is, whether it had anything to do whatever with the power of the courts to restrain the states as against the federal government. But the other point to remember, and then I will shut up after this one, is even if the Ninth Amendment was designed to give judicial power to enforce unenumerated rights against the government, or at least the federal government, it is also the case that that grant of power was based on natural law conceptions which were not only expansive but which were highly disciplined. That is to say that there was a very strong body of coherent substantive doctrine on what did count and what did not count as fundamental law for purposes of the natural law. And what it seems to me would be entirely illegitimate would be to take the, if you will, the positive or power-giving provisions of the Ninth Amendment and completely lose sight of the fact that today we have lost the sense of discipline or boundary as to what this natural law domain was. That is, with the erosion of the notion since the Palco days that there is a cognizable judicial function in determining that some rights are basic to civilized society, but others are not. That is to say, a disciplined notion of the fundamental tenets, if you will, of these natural law conclusions. To allow the Ninth Amendment to reign without those, it seems to me, again, would be to completely depart from the music and the body language of the Constitution.
Professor Michael S. Moore is a Robert Kingsley Professor of Law at the University of Southern California. He received his undergraduate degree from the University of Oregon and his JD and SJD from Harvard. Professor Moore was an associate professor at the University of Kansas Law School, visiting professor at Stanford and Cal Berkeley, and a fellow in law and humanities at Harvard before joining the faculty of USC in 1977. Professor Moore has written several articles in the area of legal philosophy, including a natural law theory of interpretation. Professor Moore.
Thank you, Nino. Well, I'm going to violate a little bit of the spoken constitution of Justice Scalia in the sense that I agree that the question, is there an unwritten constitution, does have an easy answer, that the answer is no, and that therefore all the interesting things have to be said after that answer rather than leading up to it. But I don't think the interesting questions are the particular interpretations of the Ninth Amendment, the Privileges and Immunities Clause, or the Due Process Clause of the 14th. We've got specific panels on that, so what I'm going to talk about is somewhat more generally the nature of the question itself and some answers to it in its different interpretations. I see the question as being a part of a more general debate that's been going on ever since Marbury versus Madison established the great power of judicial review, the question about how that power should be exercised with restraint or with somewhat more activist use. That's a debate that's taken a lot of forms, but if you look at the last 15 years of constitutional scholarship, the forms seem to me to be three, and they come as an ordered triad. One of those is what used to be called the interpretivist, non-interpretivist debate. That was a debate framed in terms of whether the judges, and usually it's the U.S. Supreme Court, but judges in general, whether judges are bound to interpret something, if they're bound to engage in interpretive legal reasoning, or whether they can engage in what Paul Bator characterized accurately as common law reasoning, reasoning that is not interpretive of a general text. It may follow old particular decisions as springboards, but common law reasoning is best seen as non-interpretive reasoning. One kind of debate, starting actually with an article called "Do We Have an Unwritten Constitution?" by Tom Gray in 1975, was the debate about interpretivism versus non-interpretivism. A second form of the debate was to concede that all decent judging, all legitimate judging is interpretivist, but to say, well, there's two kinds of interpretivism depending on what it is that you want to interpret. There's interpretivism of what Gray called in a supplemental article textual kind, namely where it comes from the written document. That's the object and the only legitimate object of interpretation. And there's interpretivism of other kinds of texts, which we ought to regard as our Constitution, a position you could call supplementalism, because the view would be, although you're interpreting something, you're not engaged in a common law method of reasoning, nonetheless, the text that you're interpreting is not the familiar written text, 6 articles and 26 amendments. It's rather some substitute for that, or at least some supplement, be it natural law, Supreme Court precedent, Constitution is what the judges say it is, and so forth, some kind of social consensus, or some other form of supplement or supplanting kind of text. That's a debate also had between those who said we should have only written constitutionalism and those who said explicitly we should have an unwritten constitution. There's a third debate to which I think most of Paul Bator's comments were directed, and I think correctly, because it seems to me that's the right debate, at least I'm going to argue shortly that it is, and that's the debate conceding that all legitimate judging is interpretivist, and that the only legitimate object for the exercise of judicial review, that is for constitutional judging, the only text is the written document in the archives, or in a recent article by one of our speakers tomorrow, either that document or something pretty close to it, apparently some changes in punctuation that Akil Amar has pointed out between the printed version and the one in the archives. But anyway, that document, given slight ambiguity of references to what that is, conceding that's the only text, the debate amongst this third form of the debate of judicial review, of judicial activists versus judicial restraint theorists, was a debate about how interpretation should take place. Should it be restrained, as Paul Bator was saying, which can be real restrained, that is value-free, or should it be more activist? Should it develop deep theories of things like liberty and the like, and apply them to the statutes that come before the court? That's a debate within the theory of interpretation by those who concede that all judging is both interpretivist and interpretive of one particular thing, the written text. Now you can see those are three different ways of framing what is often the same debate, not always, but often the same debate. You can imagine three different kinds of criticism, say, of Douglas's opinion in Griswold, one of the motivations for conferences such as this one. That opinion could be said by someone who I would call a restraint theorist to be Douglas was not interpreting anything. He was engaged in policy analysis and deciding as a matter of sound social policy what he thought about a Connecticut law on contraceptives. That would be to take the first way of putting it. Second way of putting it would be Douglas was interpreting something, but it sure wasn't the written document. He was interpreting either prior Supreme Court precedent, the 1920s cases that McReynolds had decided on the basis of liberty, or he was basing it on social consensus, Chief Justice Earl Warren's evolving standards of decency that mark the progress of a maturing society, or he was basing it on some natural law text, but in any case, he wasn't interpreting the Constitution. That would be the second kind of restraint complaint. Third complaint would be, well, he was basing it on the constitutional text, a lot of text, First, Fourth, Fifth, Sixth, Ninth, 14th Amendments. It was on the text, but it simply was too freewheeling to be good interpretation of that text. It was a bad interpretive method, not that he used an unwritten constitution. So what we face on this panel, I see, as two questions. One is a methodological question, namely the question, what's the right way to frame the debate? Put another way, what's the right question to ask? And then, secondly, on the merits, once the debate is rightly framed, what's the answer? So let me spend half my time talking about the nature of the debate in these three different forms, argue that only the third is the right way to put it, and then have a few remarks on interpretation theory itself. Coming then to the methodological question, think about this interpretivist, non-interpretivist distinction and what it comes to. An interpretivist mode of reasoning, and this isn't true of just law, it's everything that's these days fashionably called hermeneutics from continental philosophy. Interpretive reasoning in general is two-step reasoning. It's reasoning that says, you first decide what the authoritative text is, and you secondly use that text as a reason for deciding the case in front of you if you're a lawyer, the dream in front of you if you're a psychoanalyst. You use that text's interpretation as a reason for decision or for action. So interpretive reasoning is two-step reasoning. Namely, you put between you and the outcome that you decide on an authoritative text and say, the reason I have to give for my decision is a reason that excludes anything but that text and its interpretation as a reason for doing what I'm going to do. Interpretive reasoning is two-step reasoning. As opposed to, for example, common law reasoning or simple, ordinary, everyday moral reasoning. At least if your view of morality is not one of a religious kind, where there's a kind of religious text, or your view of morality is not one of a conventional kind, where there's a kind of social text, then you should say of moral reasoning, what I would say of it, since I don't hold either of those views, that it is non-interpretive legal reasoning, non-interpretive moral reasoning. You're trying to figure out what all things considered is the best thing to do without interposing an authoritative text that you have to interpret. So, not all reasoning is interpretive, certainly not all legal reasoning is interpretive. The interpretivist, non-interpretivist debate in constitutional law was that all constitutional reasoning ought to be legitimate, to be interpretive. Now, the reason I don't think that was a fruitful debate, and the reason even those who put the debate in those terms, like Tom Gray and Mike Perry, eventually abandoned it, was because it's too obvious what the answer is. Under constitutional notions, why would we set up an institution to engage in non-interpretive judicial review? There, I think John Ely's fine book is very persuasive. In a democracy that you're relatively proud of as being democratic, why on earth would you set up an institution not to interpret an authoritative text of any kind, but simply as a matter of all things considered moral judgment, sit in judgment on the output of the democratic institutions? The reason I think even people who are activists, like Tom Gray, abandoned that way of putting the argument is because once you put it that way, the answer seems pretty obvious. Non-interpretive judicial review seems illegitimate. Gray actually got a letter from a practitioner that changed his mind on that. The practitioner said, all legal reasoning under the Constitution must be interpretive, mustn't it? Gray thought about it for a while and said, yes, so he wrote another article. And that's the second way this debate has come to be packaged, using Gray's terminology the second time around. All reasoning, he said, is interpretive. At least all constitutional legal reasoning is interpretive. The real question is what it is that we're interpreting, or at least what it is the courts ought to be interpreting. The written document or something else. Ask yourself again what that distinction comes to. It's pretty clear with regard to the sorts of things that I think were mentioned by Nino in his opening remarks. If you're talking about Supreme Court decisions or shared consensus or natural law, that's not part of the written document. That is to use a supplement to the written document. That would be unwritten constitutionalism if this is the way we're supposed to talk about it. As opposed to the written document, which is in the archives, as I've mentioned. But if you think about what a written document is, there's hidden ambiguity, as Paul Bator was mentioning. You have to have a theory about the nature of the document before you can say to yourself, this is the text, the unproblematically authoritative text, and the rest of what we or judges should do is all interpretation. consider different ways of thinking about the document. You could think about the document as simply a set of marks on paper, the way linguists talk about syntactic strings of symbols. They're well formed, but they don't yet have an interpretation. They don't yet have a meaning. One way of thinking of the Constitution is simply as such a string of uninterpreted symbols. And what would have authority on this view would simply be the document as written, no matter what it means. A second notion is what you can call the semantic Constitution, where you assign the words their usual, ordinary English semantics. That means that you give them what you can find out of typical dictionaries or other sources of semantics, their usual English meanings. A third notion is richer. It's called the pragmatist Constitution, not in the sense of pragmatic philosophy, that it's practical, but rather in the sense that you interpret the document by the context in which it's uttered. Here we care not so much about what the words mean as what the speaker meant by uttering those words, or what the original audience who heard those words understood by them. That pragmatic Constitution, of course, is a definition or form of originalism as a theory that says you should consider as authoritative not just the marks on the paper, but the marks on the paper as already interpreted by the context of their utterance, 1787, 1868, whatever that context might be. That's a much richer notion of the Constitution. I think that one has to, if we're considering what is the text that's authoritative for this purpose of then deciding what it is that we're talking about as a supplement to it, I think we need to talk about the syntactic Constitution as the only Constitution that has unproblematic authority, and put everything else either as an unwritten supplement or as into the theory of interpretation. The reason for that comes from the nature of authority. Imagine a religious person who says to you, the Bible has a lot of authority for me. It has authority because I've read it. It's not just that God said it, but I've read it, I've seen what it meant, and by and large it commands the good and the just. That person, by any ordinary notion of authority, doesn't grant the document authority, because that person already interprets the document, sees that it agrees with what he antecedently has judged to be good and just, and then says, and only then says, and therefore it has authority. It doesn't have authority. What has authority are his own judgments. The document itself does not, in such a case, have authority. To have authority, he has to go the other way. He has to say, I don't know what's good until God tells me, but I do know that if it's the Word of God, it's authoritative, and then I'll figure out what's good as an interpretation of that word. That is to give a religious text authority, but notice it gives it authority without knowing what it means. Sort of like the McCloskey studies of the American public. They don't know what the Bill of Rights means, but they like them. They'll vote for them if you call them the Bill of Rights, not if you don't. That sort of notion is to say what has authority unproblematically is the written text considered as an uninterpreted set of symbols. Now that little bit of analysis about what authority is has the following payoff. If someone wants to argue for restraint on originalist grounds, then I think Paul Bator's characterization was right. That's a form of an unwritten Constitution thesis. Because if the right question is, if we're talking about whether it's the written document or something else that is the text, if that's the right question, if that's where a restraint theorist wants to make his stand, then he's an unwritten Constitution theorist. He's someone who's saying the stuff that took place in 1787 or in 1868 or whenever these texts were enacted has as much authority as the written marks themselves. That person is an unwritten Constitution theorist. Few restraint theorists, I think, want to think of themselves in those terms. When they think of unwritten Constitution theorists, they think of people like Tom Gray, Mike Perry, people who avowedly say we should look to values of one sort or another. In any event, it seems to me the restraint theorist doesn't want to have this debate. Better to make the debate in the theory of interpretation rather than a theory about what the text is. Better to see courts as having competing theories of interpreting the written document rather than having competing theories about how much you can add to it, supplement the text. I think that's true for activists, theorists as well, although the argument is longer. Basically, it depends on thinking that the only thing that has authority, unproblematically, is the written document, and not what the Supreme Court has said. You don't have to go as far as the famous speech by Attorney General Meese. Not what the Supreme Court has said, not social consensus, not anything else but those written marks on the page. That's what has unproblematic authority in our society, and that should be considered the only written constitution, the only object of interpretation. Activists can say that as well as restraint theorists, because the real debate should take place within the theory of interpretation. How are you going to interpret those marks on the page? Basically, it should leave you thinking the only constitution is the one that Hugo Black liked, the one he kept pulling out of his pocket. That little text, which the bicentennial has all given us many copies of in the last year. Anyway, let me turn from the two ways of framing the debate I think are unfruitful because they don't frame genuine questions about which there should be disagreement, to the fruitful way of framing it, which is within the theory of interpretation. How should one interpret the text in an activist way or in a restrained way, in a heavily value-laden way or in a somewhat less value-laden way, perhaps even a value-free way? There are two kinds of arguments in this debate as well over the last decade in constitutional scholarship. The main game is played with normative arguments where it should be played. Arguments from social contract theory, from democracy, from rule of law values, and from straightforward consequentialism, what sorts of things, all things considered, make for better results in our society. Those are all legitimate, I think, forms of normative argument about how best to interpret this document. Let me leave those. I've spent a long time arguing that elsewhere. What I want to talk about are the other sorts of arguments, what I call possibility arguments. Arguments designed to show you that one or other of these kinds of interpretive theories isn't possible. Because if it isn't possible, you really shouldn't be doing it. At least it doesn't make any sense to be trying to do something you can't possibly do. I and a lot of other people have made a lot of arguments about why originalist interpretive theories are by and large not possible, at least in their more naive formulations. Let me go to the other side of the track and talk about the possibility argument against activist theories. Namely, the argument is that you can't have activist theories the way they're practiced, at least, the way that they're touted by theorists, and still have an interpretation of a written text, or at least not of our written text. The argument is if you're as freewheeling as activist interpretive theories would let you be as a judge, then you can say you're interpreting a text, but functionally you're engaged in either non-interpretive review or functionally you're really interpreting a text other than the written one of 1787. Let me turn to that possibility argument. If you look at the way it's made, it's mostly a linguistic argument. It's an argument that looks at clauses of the Constitution and say that they don't provide enough guidance to constrain judges. That can be made in general about the Constitution vis-a-vis, say, statutes, or you can make that argument, as John Ely does, with respect to the problematic clauses, the general ones, the Ninth Amendment, due process, privileges and immunities, and equal protection, and say that those clauses are sufficiently non-guidance providing that any attempt to interpret them is bogus interpretation, particularly if engaged in the freewheeling way of an activist. What I want to argue is that that isn't true, that there are theories of meaning that undercut the linguistic objections of restraint theorists, that those particular clauses can't guide judgment of judges. If you look at the way those arguments are made, they're usually parsed into the following way. The language is too general, first problem. It's too vague, second problem. It's too open-textured, third problem. It's too ambiguous, fourth problem. It's too evaluative, fifth problem. Or it's too implicitly or explicitly delegative to future generations to fill in the clauses with their own values, sixth problem. In all of those ways, the language of the Constitution, or at least the general clauses of it, is thought to be problematic. The general problem is you're supposed to run out of meaning, that it doesn't guide a judge by the meaning of those clauses. That claim depends on what you think meaning is. It depends whether or not you think meaning is the sort of thing that runs out when a speaker of the language doesn't know what to say. Let me just very briefly talk about different kinds of meaning theories, and there is no help for doing some philosophy of language. That's where the game is ultimately won or lost. What kind of meaning theories are available to judges or to anyone else who uses a natural language like English? Very broadly, given the shortness of time, although I am gratified to the committee this year giving us 15 minutes rather than 10, which is what it was last year. But then I complained that nobody stuck to the 10-minute limit anyway last year, even if they were intentionalist or textualist interpreters. Anyway, let me run through quickly the three major kinds of meaning theories that there are. They're conventionalist theories that say that the meaning of a word like death is given by a set of linguistic conventions that are abstracted from the usage patterns of native speakers of the language. Death is defined as cessation of heart function, cessation of lung function, loss of consciousness, brain death, different ways of defining it. There's certain definitions that can be abstracted from the way we use the word. Or there's certain paradigmatic examples, really dead people from which the meaning of the word is garnered. That's a conventionalist theory, usually favored by those who are called plain meaning theorists of interpretation. There are also those who urge that the meaning of a word should be found in the context of its utterance, and therefore you look to the intention of the user or the beliefs of his original audience to find what the word meant as used on this occasion. So if somebody said, Joe is dead on a particular occasion, to know what dead means as used would be to ask of the speaker what his intended exemplars were, or his intended concepts of death were, definitions, theories, in order to find out what he meant by the word, or on the audience view, what the audience understood it to mean in terms of their exemplars or their concepts and definitions. Now, it seems to me both of those theories about words like death, at least, are simply wrong as a matter of linguistics. Come to the law in a moment. Wrong as a matter of linguistics because they try to fix the meaning of the word by a set of intentions, beliefs, or conventions, rather than by the nature of the thing to which the word refers. Imagine the following case of some years ago, an actual situation. Someone whose heart, lung, and so forth functioning has stopped, who has lost consciousness, and who is conventionally regarded as dead and is said to be dead by lots of folks. It turns out somebody else comes along who's a doctor and says, I don't think he's really dead. Doctor says he's not really dead because he's been submersed in cold water. And if you knew what I think is true, you would find out he could be, quote, brought back to life, i.e. he's not really dead. Now, if death, the meaning of the word, were simply fixed by these conventions, beliefs, or intentions, that should be a proposal to stipulate a change in meaning of the word. And yet no one believes, in linguistics at least, you're changing the meaning. You're talking about the same thing you were always talking about. You just learned a little bit more about what death is. Apply that to the Constitution's great phrases. Suppose, as Paul Bator pointed out accurately, I think, the users of the language were those who believed in natural law. They thought the word liberty referred to liberty. They thought the word equal protection of the laws referred to equality. They thought cruel punishments referred to those cruel punishments that could exist, not just the ones they knew of. That theory of meaning would say that the meaning of those phrases is given by the nature of the thing to which the words refer. And you do have to be a natural lawyer to make this argument, because you have to think those things exist. But suppose you're with the framers, at least with Hamilton and with Madison, true sons of the Enlightenment, as Morton White's recent book argues in detail, who believe there are such entities. If that's your meta-ethical belief, then the meaning of the word liberty doesn't run out because it's vague. It is vague. That only means the conventions of ordinary speakers run out. But the meaning of the word, just like the meaning of death, is given by the best theory of the thing to which that word refers. And if you're going to use a word like liberty and mean it as a restraint on democratic government and a protection of minority rights, then you're going to mean that courts who share your view of the ethical world, a natural law view, should indeed develop a nature of that thing, just like they should develop a nature of death if you were to use that word, or tiger, or gold, or polio, or any of the other natural kind words of ordinary speech. That because you intended, not for your own definitions or examples, to be what gave the word its meaning. If you're an ordinary speaker of the language, you know that your theory could be wrong in certain respects. You could think that a tiger, for example, had to have stripes and you didn't know about albino tigers. You would know that your theory could be wrong. What you intended to name was a class of events or things, leaving it to whoever has to apply that word to figure out what the best theory of that class might be. You may have a theory, you may not as a speaker, but nonetheless you leave it to others to figure out. Now that's not, at least it's not quite, the famous interpretive intent debate of Raoul Berger and H. Jefferson Powell, and a new paper by Mark Tushnet weighing in, not surprisingly, on Powell's side of that debate. That's not quite that point. It's not the point that the framers explicitly had an intent about how to interpret the document. The point is rather, even if they had no intent about how to interpret the document, if they were using language as a natural lawyer would use it, then they were referring to entities which, to interpret the language, requires you, like they, have a theory of, if you're a judge. That wouldn't make it illegitimate. That would make it doing exactly what the framers would have envisioned with respect to interpretation of those kinds of clauses. Now, what if you're not a natural lawyer? What if you're like people today, many of whom don't share those premises? That's not me, but let me play this game for a moment. Then you're like what John Ely describes. You're the person, if you're a judge, who has to interpret a statute about ghosts when you don't believe in ghosts. Seems to me you only got three choices. One, you can say, I won't apply the statute. They thought there were ghosts, they said ghosts, and I have nothing to say. Second thing you could do would be, well, they thought there were ghosts, they said ghosts, there are no ghosts, so I will take it as an invitation to engage in non-interpretive review. I can't interpret it, but I will engage in judicial review. Second possibility. Third possibility is you can engage in what I would call a kind of crabbed originalism. Namely, you take those who used the word ghost and ask, well, what were the exemplars they had in mind, and what were the concepts of ghosthood they had in mind, even though the thing to which they were referring doesn't exist. That, it seems to me, is the least desirable of the three alternatives, because that doesn't play fair with what they thought they were doing, which is naming ghosts. If you want to play fair with it, take it as an invitation or don't do it at all. The least justifiable alternative is to take the middle ground. There's another kind of problem for those of you who may in fact have at least some quiverings of desire towards what's called moral realism or natural law. A kind of objection that was raised by Stanley Brubaker a couple of years ago.
The moderator has some quiverings of desire to move on. I think we take another 3 minutes. We won't have any time for questions.
Right, okay, fair enough.
Besides questions, don't forget me.
I mean, we won't have time for questions at the end.
Oh,
We usually just have two arguments on the court. There's never a third party.
Let me just raise an objection that a colleague of mine raised that has been raised by others as well, which is even if there is this stuff called natural law, suppose you're not a skeptic. You believe, in fact, as the framers did, at least some of them, that there is a natural law to which the grand clauses of the Constitution were attempting to refer. They're not very knowable. Even if they're there and in that sense constrain a judge, they don't really constrain a judge because there's so much dispute about them. If they're not knowable and agreement is hard, then in what sense do they constrain? Well, Madison and Hamilton weren't unaware of that problem. If you recall, they had an argument that said, in effect, very few people know what virtue is. They have neither the skill nor, more importantly, the integrity to figure it out. So if you're going to worry about this in terms of who's on the bench, it seems to me you should say, the main thing to be sure of is you get the right judges on the bench. They're the ones who know what liberty is and believe there is such a thing to have knowledge of. Then those judges are constrained. Of course, the trick is to figure out who they are. Not a small trick, but nonetheless, a recognizable problem to which, if I were sitting on the Judiciary Committee, I'd have an answer. Pick the ones who in fact believe, as the framers did, in things like liberty and equality. And then I'd also want to know what they think those are before I confirmed, because it makes a lot of difference. In any event, the general point is simply this. The true error of originalism ought to be an activist interpretive theory. If you really want to do what the framers had in mind, do it with respect to figuring out, as a matter of the theory of liberty or other clauses, what those things are. That will turn out to involve one in a lot of theory building of a moral kind, but that is, after all, what the document seems to demand. Thanks.
Thank you, Professor Moore. Our last panelist, whom I hadn't forgotten, is Professor Ronald Rotunda, Professor of Law at the University of Illinois. He graduated magna cum laude from both Harvard College and Harvard Law School, where he was a member of the Law Review. He served as law clerk to Judge Walter Mansfield of the Second Circuit and as assistant majority counsel to the Senate Watergate Committee before accepting his current position at Illinois. He's a former Fulbright research scholar and has recently completed a Fulbright professorship in Venezuela. Professor Rotunda is another casebook author, numerous articles as well. The casebook is called Constitutional Law, 3rd edition, written with Novak and Young, and also Constitutional Law, Principle, and Cases. Professor Rotunda.
Thank you. I'm going to stand up if that's all right. I've been sitting.
I should have made everybody stand. I think
Yeah.
it's a good discipline, don't you?
I think so. I'm not that tall, and most people don't notice it. I got on a plane at 6 a.m. this morning in Champaign, Illinois. It doesn't have rolling hills. It's kind of flat. It's an acquired taste. We sat there for about an hour because of an ice storm in Dayton. We got to Dayton. I missed that plane by 1 minute. The same. It didn't change. I mean, I didn't change airlines. The same Piedmont. 1 minute, and I spent lovely. I think it was 3 hours in Dayton and another 3 in Charlotte, North Carolina. Came to the hotel, feeling like more than anything else, I wanted a shower, but there was, of course, no electricity, so they couldn't get me in the room because it's all this magnetic stuff. Computers, the devil's invention. Finally, I got in the hotel, got the shower, looked at all my materials, and I must say, Southern hospitality, I was pleased. If I could not be the first Italian-American on the court, at least I had a building named after me in this town. And that's more than... I will try to be brief because right after me, I guess, is the cocktails and all that. I don't want to stop. It's frequently said in jest that one of the important things we share with the British is we're both governed by an unwritten constitution. I think the point was illustrated a few years ago by a casebook author, not me, put together a constitutional law casebook that was published without reprinting the Constitution. I suspect maybe the editors felt, why look at it? The judges never do. No offense, I call them as I see them. Our Constitution is unlike, just in form, is unlike, for example, a lot of Eastern European or the Soviet Constitution. You look at that Constitution, it grants a lot of things that we would think would be basic to life. The right to a job, the right to eat, the right to drink water. Basic things are granted in that Constitution. You don't find them in ours. We talk about things like the right to vote without regard to sex or race, or the right of free speech, religion. The notion is people can use these rights in a democratic system to enact laws which can guarantee welfare payments if they wish, or free public education, or unemployment benefits to whatever extent they wish. Our Constitution is basically, part of it is like the Mayflower complex, it's structural in form. One group limits another. It's what we call checks and balances. A concept really reflected the 18th century fascination with Newtonian physics. And most of our rest of the Constitution, particularly the Bill of Rights, is written in the thou shalt not form, like the Magna Carta. The parts of our Constitution which are written in the thou shalt not form contain a magnificent list of rights: freedom of speech, press, free exercise of religion, Congress shall guarantee, the right that no one shall be deprived of life, liberty, or property without due process of law. The list can go on, well beyond this small sampling. Now, when the court interprets the Constitution, it uses these magnificent generalities. Why is it necessary to go beyond that to the unwritten Constitution? The written one certainly has a lot of play in the joints. And if the Constitution if the court does turn to an unwritten constitution, is it going to be worth the paper it's printed on? For most of our history, the court has engaged in what is called interpretive review. Michael Perry, for example, leading non-interpretivist, I think defines interpretive review correctly as when the court, he says, ascertains the constitutionality of a given policy choice by reference to one of the value judgments of which the Constitution consists. That is, by reference to a value judgment embodied, though not necessarily explicitly, in some particular provision of the text of the Constitution or the overall structure of the government ordained by the Constitution. The legitimacy of interpretive review, as Professor Perry acknowledges, is not difficult to justify, he says. In recent years, more and more commentators have urged the court to adopt, frankly, non-interpretive review in deciding constitutional cases. And Michael Perry and others candidly admit that the justification for non-interpretive review is more troublesome. I just looked through some of the articles. How should the court decide? One commentator says it should look to, quote, the voice and conscience of contemporary society, end quote. Michael Perry says that judges should look for the, quote, right answers, quote, he says, in order to go beyond the value judgments established by the framers of the written Constitution, which he calls, frankly, extra-constitutional policymaking. These people see it as the Constitution as a blueprint, not so much for allocating power and limiting the abuse of power, but really for a way for judges to forge an ideal society, or maybe more correctly, what these people view as their view of an ideal society. Larry Tribe said, for example, courts should engage in what he calls a more candidly creative role. So the highest mission of the court is not to conserve judicial credibility, but to form a more perfect union, which is actually a phrase you find in the Constitution, but never one we thought the court was supposed to use in deciding cases. Well, more perfect than that. When judges go beyond the written Constitution, usually, ultimately, they look inside themselves. Now, I find it, as a lawyer, more illuminating to talk about concrete cases and not abstract things. I pick a case, interesting, I think, because it's recent. It's called Tashian versus Republican Party of Connecticut. And I think it shows some of the justices looking within themselves. Strongly divided court, 5-4. By the way, Justice Scalia dissented in that case. That's not why I picked it. It's not hard to find a case where he dissented, but I thought this one was particularly interesting. The court invalidated a Connecticut law because it said the Connecticut law conflicted with a Connecticut Republican Party rule. The party rule permitted independent voters to vote in the Republican primary for federal and statewide offices. State law provided for a closed primary, like a lot of states. The Republican Party rules provided for an open primary for federal and statewide offices and a closed primary for other offices, for example, state legislator, mayor, stuff like that. The state law providing for the closed primary was not particularly restrictive. That wasn't an issue. You could enroll in the Republican primary as late as noon on the last business day preceding the primary. It's not one of these cases that said you had to be a party member for 15 or 24 months before the election. Why did the party rule reject the state law, which wasn't particularly restrictive? Why did it draw its own very peculiar restriction, that is, open primary for statewide offices, closed primary for non-statewide offices? The court doesn't tell us, but buried deep in the record, we learn the answer. It's in the plaintiff's admissions of non-objected facts, their stipulations. Seems that Senator Weicker from Connecticut, in a re-election bid, was concerned that he could not win a primary without an influx of non-Republican voters. The other Republicans said, wait a second now, we don't want these independents voting in our primary when I'm running for mayor or state legislator. Said, okay, we'll work up a compromise. The party rule will say that independents can vote in my primary, but not in yours. Out of that prosaic concern, the Supreme Court majority fashions a new constitutional right. A right not easily created because it appears to conflict with earlier precedent. 1976 case, 3-judge court in Connecticut, federal court, upheld the Connecticut closed primary law and the Supreme Court affirmed. Summarily, by the way. The Supreme Court, Justice Marshall for the majority, says, we approve of the 1976 decision upholding the closed primary, but that's a different case because the plaintiff there was not the Republican Party, it was an independent voter. And on that distinction, apparently, the Constitution is determined. It says it was a constitutional dimension because the party argued that the state law impermissibly restricted the rights of the members to determine for themselves with whom they will associate. That's kind of interesting. The court doesn't cite any constitutional provision to support this surprising conclusion. Could a Republican Party or Democratic Party, as the Southern Democratic Party did for years, exclude by party rule blacks from participating in their primaries? I don't think the court means that. But it did say that a political party has a constitutional right to determine for themselves with whom they will associate. But we solve that problem by simply saying, well, the court didn't really mean that. Which is what we say about a lot of the vague language in some of their opinions. It's really very unfortunate. It said the state statute was unconstitutional, it didn't advance any compelling state interest. Now, I believe in the freedom of association just as much as the next person. It's a right, I think, easily derived from the First Amendment. The leading case in the area, you probably know, is Roberts versus United States J.C.'s. The Tashin court never cites Roberts' case. That's kind of interesting. If you look at Roberts, maybe you know why. Roberts affirmed the power of the state to regulate what it called large, non-intimate associations, while stating that the state's power became more limited as the association became more private. And they gave the example marriage. Applying the text of Roberts, you think that a statewide or national political party is not a particularly intimate association. For years, states have regulated parties, as has the federal government. The dissent pointed out, Justice Scalia says, Connecticut may lawfully require that significant elements of the democratic process be democratic, whether the party wants it or not. This is beyond my understanding why the Republican Party's delegation of its democratic choice to a Republican convention can be prescribed, but its delegation of that choice to non-members for the party cannot be. And quote, well, the court doesn't tell us why either. It's a small example, I think, of where a majority of the court left the written Constitution in their haste to come to a conclusion which they viewed as good policy. They left not only the Constitution, they left their own precedent of Roberts and created yet another piece of confusion which gives more meat to those of us who write treatises in constitutional law. Now, even proponents of natural law theory of the Constitution appreciate there must be some limits to judicial power. Professor Perry, for example, in his book argued that limitation would be that Congress could always restrict the jurisdiction of the courts. Once we acquiesce in Congress overruling constitutional decisions by means of a simple statute, I think we've gone a very long way in weakening judicial review. Once Congress drinks of this power, will they know where to stop? I think they'll probably act like with the little boy that said he knew about how to spell banana but didn't know when to stop. Several years ago, a famous judge noted in a speech, this is about 3 years ago, he said, quote, "Justices are not Platonic guardians appointed to wield authority according to their personal moral predilections," end quote. In today's climate, these sentiments are surprisingly very controversial. The justice, by the way, who said that was William Brennan. Some time ago, a Peanuts comic strip showed Snoopy the dog looking at Charlie Brown and Linus. Snoopy's thinking to himself, I wonder, why are some of us born dogs and others are born people? Is it just chance or what is it? Somehow the whole thing just seems unfair. Then he concludes, why should I be the lucky one? Well, it's a question we should ask. It is, why are we the lucky ones? We've been very fortunate in this country to have a Supreme Court to help preserve our constitutional rights. Travel abroad in Europe, South America. They look with envy in our court. Hopefully our luck will hold out. We recognize the court is sometimes engaged in excesses. That's just the nature of an institution inhabited by human beings. What's troubling, though, is that modern academic commentary should pressure the court to get back on track. Nowadays, the pressure is exactly in the opposite direction. I think that's really not good for the long-term health of the court. We won't always be the lucky ones. Thank you.
I think I'm going to pass at this point and hopefully get to the questions.
Well, having taken so much time, that would probably be the gentlemanly thing to do. But I'll restrain myself and ask Paul a question so that he won't be restrained either. It really is a question about statutes that have broad language, because in Paul's argument about the Ninth Amendment, giving it a standard Federalist interpretation seems to basically make it a duplicate of the 10th. Why would one strain to stay away from figuring out unenumerated rights? I guess the question for statutory analogy would be, in a child custody dispute, what's one going to do with a statute that says give the child to the parent who will maximize the best interest of the child? There's an interpretive task that seems pretty open-ended too, and I doubt that one wants to strain to make that clause non-operative.
Well, I'm not absolutely sure I understand the question. It seems to me the question that I put to myself about the Ninth Amendment is whether it is to be seen as an instruction to the federal courts to operate the engine by the method of the common law. That is, whether it's a shorthand to allow the federal courts a general common law power to take the Constitution as an engine and run it where they will. It seems to me it would be enormously surprising and puzzling to think that that is what was in mind. And it would be even more surprising and puzzling to think that that was in mind and at the same time, the very determinate and disciplined form of whatever natural law thinking infused the Ninth Amendment should not accompany that engine. That's my puzzle about the Ninth Amendment and the theory that it is a shorthand for a very wide delegation of legislative policy-making common law power to the courts. It would be a huge puzzle, I think, to think of that. Now I'm really going back to a point I made before. It seems to me entirely incoherent to think that that is what they had in mind in the Ninth Amendment. And then they immediately passed the 10th. It seems to me that would be an entirely incoherent way of understanding the Constitution. It's not a direct answer, but it's a deflected answer.
Ron?
I'll waive for now.
All right. We will take questions from the floor. Yes.
I hope it doesn't appear ungentlemanly, but I'd like to ask Professor Moore a question. And my question has to do with the natural law. And you mentioned several possible interpretations of the Constitution. And I'd like for you to address the question of natural law as it was defined by Blackstone and Bracton as the laws of nature and nature's God as written in the Declaration. And is that a viable method for interpreting the Constitution, since it was written within that framework and had a very specific meaning?
Well, let me distinguish two things about Blackstone, his meta-ethical views and his substantive views on the merits as to what is good and bad, right and wrong. Whether meta-ethically he was really a natural lawyer, I think, is open to debate. There are certainly passages in the commentaries that say it. There are also passages that sound extremely positivistic with regard to the law. But in terms of using Blackstone as a means of filling out our Constitution, if that's where the question's going, in terms of what he took to be the content of the natural law, that's not a place I would find very authoritative. Blackstone had a theory, although he was such an apologist for the writ system with which he was familiar that he sort of crammed it all together to fit that. But he simply had a theory as to its content, as certainly Madison and Hamilton in part had theories about what sorts of rights persons possess because they're persons. That doesn't mean that we want to take Blackstone's theories, even if some of the revolutionaries and the Constitution drafters read Blackstone, as filling out for us, say, what free speech means. because I think the meta-ethical views of the framers, actually clearer than Blackstone, was to name a freedom, a distinct liberty they thought persons possessed, and that means to guide the meaning of that clause by the nature of the thing, not by what Blackstone thought, and certainly not what Madison himself may have thought, or any of the other drafters later on in 1791.
Yes. Please speak up and asking the questions. You're close to us, you're not close to everybody else.
Sure. Perhaps you're familiar with Professor Harry Jaffa. He wrote an article, I guess, similar to what Professor Moore is proposing on original intent and natural law. In the latest National Review, he talks about the big mistake over Judge Bork. And Judge Bork's view, William Rehnquist's view, and Attorney General Meese's view that the natural law really has no place in interpreting the Constitution. It seems that what's been said maybe a little bit by Professor Bator and Professor Moore disagrees with this, the natural law can be used. I'm wondering how, if conservatives adopt that position, and Professor Moore has admitted it be an activist conservative jurisprudence, how we distinguish ourselves from William Brennan and the liberals, who also propose a modern analog to that natural law, fundamental rights, human dignity. How are we to distinguish a conservative jurisprudence and not be activists at the same time, as opposed to the principled manner which Bork, Meese, and Rehnquist have been trying to do it?
It's his idea. Let him to handle it.
That was part of the burden of that triple-layered distinction about what the unwritten Constitution debate is about, was to allow one not to say, as I think accurately Michael Perry at least one time did say, and I'm not sure Brennan ever has been that incautious, to say that you're engaged in non-interpretive review and filling out the clauses, or to say that there's an unwritten Constitution that's just as authoritative as the written document, or maybe even more so. I don't think anyone should say either of those things. That would distinguish it, at least from the incautious formulations of the activist view that Michael Perry put forward, although he did recant some of that just a few years ago. In terms of the content, difference, of course, is one of them would be politically conservative and the other would not. There's quite a difference between Richard Epstein's notions of liberty and property and Justice Brennan's, even if both of them are activists.
Well, I suppose that's so if you take Epstein's natural law. I mean, whose natural law does one take?
You know, that's one of the problems with activism. It's a knife that cuts both ways, and that as judges become more and more activist, people in general are going to be less like their results, less and less. That right now there's seems like a great deal of political pressure supporting the decisions of the court, though it's interesting that even prior to the court packing plan, 1936-37, while the polls then showed that while the average person didn't like the results of the court, that is, they thought the federal government ought to be able to regulate certain areas, interstate commerce and all that, that the court was still a popular institution. And the court was then being attacked very dramatically by the commentators. But that's absolutely right, that there really is a similarity, I think, between Richard Epstein and William Brennan. The difference happens to be in what the particular results are.
Let me just make one point of clarification. I am violently opposed to an activist jurisprudence, whether it is conservative, liberal, or anything else. I simply wanted to say that, make a contingent point, which is that if some natural law thinking is to be infused into the Constitution, then it cannot be an anachronistic or modernized or modernist version of a natural law jurisprudence that wholly forgets what might be called the limited scope of those notions of ordered liberty, which originally were thought to inform that notion. The only other point I wanted to make was not a natural law concept at all, which is that within an interpretivist tradition, it is extremely important, as Professor Moore said, not to think of that as an impoverished and I think incoherent way of dealing with the text basically as dead letter, as literal letter, dead letter. That's not the equivalent, I think, of a common law engine or a natural law engine for taking the Constitution where it doesn't cover at all. On the general issue, I am absolutely in Professor Rotunda's corner.
Or circle, yes.
Yes. Just. Yes, you don't want to be in a corner, do you?
No.
I suggest for future questions, there's a mic here and a mic there. Why don't you just line up in whatever order you want, and we'll go from one to the other.
Justice Scalia, I have not yet seen the slip opinion on the court's decision in the Falwell versus Flint case. When I see it, I'll be anxious to see whether the court has recognized what we learned in law school as the Rotunda corollary to the Stewart definition of obscenity, which is I can't tell you what it is, but I know what I like. I found the panel's comments wonderfully.
Mr. Gleanis was a student of mine many years ago.
I found the panel's comments wonderfully informative, but at a very high level of abstraction. And I think it's worth taking a moment to get back to the paradigmatic case that's before us every time we look at an instance where a court overrules a statute that's been adopted by a legislature, usually a state legislature when we're talking about exercise of the judicial review function by the federal courts. What happens is, in effect, the will of an elected body of officials is being overturned by a life-tenured, unelected, non-electorally responsible court. Now, you can say that that's all right in certain circumstances by a number of different arguments. The one that's most palatable of which to me, and I think also to Dean Ely, was that where you're working from language in the constitutional text that's very clear, it's not hard to say that by the adoption of the Constitution, the drafting by the founders and the ratification by the states, there is a pretty clear case of consent by the states and by their through their representatives by the residents of the states to the process that results in the overturning of a legislatively adopted statute by judges. But when you have to rely to overturn a statute on one of these open-ended phrases, undefined terms in the Constitution, where you really don't have a clear black-letter basis for overturning the statute, isn't it better to rely on what at least was once the presumption that the meaning of the will of the people was best expressed through their elected representatives?
You will probably get the answer.
Sounds good to me.
No, yes, and maybe. Do you want to go through it?
You sound like a consent theorist, and I guess one would want to know what's the consent that counts. Is it the consent at the time the document was drafted of the people who signed on to it in one way or another? After all, we don't have just a democratic system. We have this thing called the compromise to which Madison's name is attached, a system that says you protect the minority against majority faction as much as the other way around, and you do that through a written constitution. So if it's the original consent, well, that's what they wrote. They even wrote that people have rights just because they're people, even though we didn't write them down in the first 8 amendments, which in a very good article by Susanna Sherry recently in the Chicago Law Review is nicely analyzed to be exactly what it says, the invitation to natural law. If the consent is current consent, that is, we have, either individually or as states, consented but only to certain specific limitations, well, again, that isn't what the document says. The document has broad clauses like equal protection, and I think it's a real quandary for people who don't share the framers' faith that equal protection names equality, a thing that has a nature that can guide judges. If you don't believe that, I think you're in the quandary I described. But in any event, consent doesn't help you there, I don't think. The document on which the consent is based has this language in it.
But that response seems to presume that the only people who can enforce these open-ended terms are the members of the federal judiciary. Can't they also be enforced by the elected representatives of the people?
Well, they certainly can. Then the question is who's ultimately governs. I guess Marbury versus Madison says Ninos.
I'm not commenting on any of this, yes.
I'd like to ask a question that bears on how concretely some of these theories might be applied to a case that came before the court. And the case that I'm thinking about is the case of the soldier who was told he was participating in a relatively safe test of something in the Army, and in fact, without his knowledge or consent, they gave him doses of LSD. And the LSD, according to the assumed facts in the case, had all the horrible effects on his life that the government has told us for years that it's supposed to, and had really a deteriorating effect on the man's marriage and life and future and so on. And I'd like to know, under Professor Moore's theory, how does that theory, if it does, bear on this case? And how would it help you resolve this case? And for Professor Bator, I'd like to know, what does judicial restraint tell you about that sort of behavior in that sort of case?
Well, one of the benefits of doing abstract theory is they often, at the level you stated, don't tell you very much about particular cases and tell you here at least a lot more. And in the case that you put, as I recall reading about it, that's a very offensive set of facts. What you want to do about sovereign immunity, for example, is something I haven't given much thought to. Notice a theory of natural law that says there are answers doesn't say that the person who puts it forward has all the answers. And I'm going to duck with that one.
I will remember that theory of natural law. It's the only one I'm sure of. There are answers. I'm writing it down.
Well, I'm going to have to duck a little bit because I don't know the material surrounding the question enough to be able to think about it in an intelligent way. That is, when a case is put, I mean, unless one has the luck of already knowing all of the surrounding legal texture, one can then start to think about, for instance, is that at common law, is that an actionable event? I would start to think about the extent to which the existing federal remedial law has now incorporated the standards of the common law into its texture under the existing case law. I would start to think about the question of there is a large body of law on the special privileges which the military has to act coercively against individuals and the bearing of that. I don't know where all of this would lead me, and at the moment I'm not even quite sure I know exactly where it intersects my theory or Professor Moore's, to tell you the truth. So I'm a little embarrassed by the question. I don't know how to answer it in an intelligent way.
It's a hard example to answer anyway, because there's a whole statutory background that was quite relevant to that case as well. It's just not a pure natural law case, if that's what.
My question is directed to Professor Moore. I don't mean to gang up on you, but if I might paraphrase...
Criticized and ignored.
If I might paraphrase part of your remarks, you say that the debate between the interpretivists and non-interpretivists is uninteresting, largely because it's enough to say that in a democracy, they would not have created a government and a Supreme Court which did not base their judicial review power in the document. Why isn't it enough then to say that the same framers and ratifiers had a conception of a meaning theory that they're creating in the judicial review? In other words, why isn't it enough to say that when they were authorizing the judicial review power recognized in Marbury versus Madison, that they would have wanted the meaning theory in that judicial review to be the intention of the speakers and the original listeners rather than the best theory of the thing which the words would signify?
A matter of necessity, there wouldn't be a reason why that couldn't be the case. One would want to see the historical evidence. Of course, judicial review was not explicitly written in. There's some stuff in the papers about it. And there's certainly this debate between Rowell, Berger, Powell, and others, Brest, Dworkin, et cetera, about what the framers' actual interpretive theory, to the extent they had one, might be. What I gave you actually is, I think, a piece of evidence, an inference that you could draw about what it must have been if you were a natural lawyer and you used the words they used. Why on earth would you think that you would use a word like free speech and think your exemplars were to guide if you thought there was a thing to which the phrase referred? You wouldn't do it if you were interpreting the word tiger in some statute barring the importation of skins of tigers. You wouldn't think that your exemplars of tiger were to be used by the interpreting court. Why would you think so about something you thought to be equally real? Free speech. It's an inference. Now, if there were explicit historical evidence the other way, that would count against the inference.
Yes, sir.
Good evening. My question is basically this. Now, how would each of you interpret, what would you use to interpret the Ninth Amendment? Would it not be an unwritten constitution per se? There's nothing there's nothing else as broad as the Ninth Amendment can be. I mean, I would assume they originally meant you have the right to get married or things to that effect that are reserved, the rights reserved to the people. But usually this seems to be interpreted using morality of some sort. For example, one guy who had married 4 women would, in our society, be bigamy and therefore illegal. But whose business would it be if it was confined to, let's say, one household? But people rule that's bigamy and that's bad, and usually that's reflected on morality. When it comes to something like drugs, okay, you have somebody, let's say, who takes marijuana or whatever in his privacy of his own home, okay, and we find this immoral and therefore illegal. Or you can use several other examples to this effect, sexual activity or something. And these always seem to be interpreted on the judicial level by using morality, which in itself is, per se, an unwritten constitution. How would each of you be able to, what would you use to interpret the Ninth Amendment when certain cases like this come up?
I will exempt Paul from this unless he wants to jump in. I think he's given his view on the Ninth Amendment extensively. I'm not sure the other two have as to how you work it. If you want to jump in.
I'll just be very brief. At the time the Bill of Rights and the first 10 amendments were adopted, there wasn't the system of judicial review we have today. That is, I do believe that the ratifiers, or that there was a general feeling that the court would have some role, but realistically, they couldn't have anticipated the powerful court we'd have today. If we try to look at the Ninth Amendment in terms of the historical milieu, it would seem, for example, that one thing it's saying for sure is that if we are going to interpret our rights, let's not interpret them unduly restrictively. The ratifiers couldn't have anticipated electronic data processing or telephones or movies, but it would be, I think, wrong for the modern court to say, well, they said speech and press, or they said Army and Navy and not Air Force. So that one thing the Ninth Amendment means is that we interpret our enumerated rights with a certain amount of generosity. Then I think there's also this notion tying it in with the 10th that we don't have, there's some kinds of limits in the role of the federal government vis-a-vis the states. But of course that in turn would be modified to some extent by the 14th Amendment. Well, one other point I make briefly, we often talk about what the framers thought, and I suppose tomorrow, not to impinge on somebody else's territory, somebody tomorrow will say, well, gee, how do we know what the framers thought? This is what I thought was Professor Powell's thesis, that they all met in private, and in a way that's true almost in a trivial sense. That is, when we interpret a statute, we don't try to psychoanalyze a legislator. We don't find it admissible that the particular senator wrote in a private letter to his son at college what he thought the statute would do. we talk about a so-called public intent, what they talked about in the halls of Congress. Similarly, when we talk about what the Constitution means, it's much more relevant, I think, to talk about things like the Federalist Papers or the state ratifying debates than to talk about what Jefferson wrote in some letter, particularly since Jefferson wasn't even at the Constitutional Convention. He was in France having a good time, probably picking up diseases and and things like that. But
Risky talk in Charlottesville.
yes,
I'll
I'm
tell you.
sorry. I forgot. Here he's still alive. But the point is that it's easy to make fun of originalism in a very simplistic sense. There's why is it relevant that Adams wrote George Washington, or why should we be bound by what was said in the convention when the notes of the convention weren't published until 50 years after the Constitution had been ratified? And the answer is, of course, we're not bound by that. It becomes a little irrelevant that there may be a typographical error in some form of the Constitution. What we should be concerned about is the historical milieu and the public intent reflected in things like the Federalist Papers.
We started a little late, so I will exercise my prerogative as a moderator to extend our session for 10 minutes, and then it's over. I think we're on this side. No, we're on that side.
On this side.
I always mix up left and right. I can't.
I'm not going to try to top these one-liners. Professor Rotunda, like you, I traveled from Illinois, and so I had the same inconvenience as you did. I may have missed a few words. So like Alice through the looking glass, you couldn't possibly have met what you said. The structure of your speech, as I heard it, and I did miss a few words, was, look at all these terrible things the Supreme Court has done. And then I might have popped off. And then I heard you say, well, we can't possibly give Congress the right that's clearly in the Constitutional to limit jurisdictions because they won't exercise it properly. They'll misuse it, even though they've restrained from using it from 200 years. And then I heard something along the lines, since we can't rely right now on academics to convince the Supreme Court to restrain itself, we should hope for a change, and we should press for that change. But the Congress has shown restraint in the use of the jurisdiction power, and if academics have failed to apply what pressure they can to high court officials to restrain, perhaps when we see these mass problems that you started out in the very beginning, we can ask ourselves, why not try using that power, the power of limiting jurisdiction, or at least propose some other reform other than the fact that academics are already unwilling to press the Supreme Court to restrain itself. So I'm a little lost.
Yeah, well, I think that, Paul Bator talked about this earlier, this compromise. We have a democratic system. We also have minority rights, and ultimately rely on the Supreme Court and the lower courts to protect that. I think that's the system we have. On the whole, it's worked well. We find in any system that the court will sometimes make mistakes, and I think the best way to try to correct those mistakes is, among other things, academic commentary, and to criticize the court, to show the court when it's gone wrong. I think that efforts to limit the jurisdiction of the Supreme Court to overturn constitutional decisions is just plain wrong. And that you say Congress has exercised restraint. Congress has never done that before. Congress has never been able to get through a bill trying to limit the Supreme Court in a constitutional matter. And I would add that if it's that easy to overturn Marbury v. Madison, I kind of wonder what all the fuss is about.
The power isn't to overturn, the power is to set up a new jurisdiction. They can't direct the court to any particular decision. So you're giving the Congress too wide a power. The Congress's right is to set up a new jurisdiction that is not equivalent with overruling. All right, so you can't say it's directed at overruling.
Well, agree to disagree.
Thank you.
Of course, to some extent, it's the devil you know for the devil you don't know. You can exclude the Supreme Court or the federal courts, but in these federal constitutional matters, the state courts are still going to have jurisdiction to decide the questions you've excluded the federal court from. Would that make you happier? I don't know, I don't remember what state you're from, but,
The phrase is usually used to mean setting up another federal court given jurisdiction, not passing it on to the state court.
But then you preclude the Supreme Court from getting jurisdiction from that court. Is that what, and I guess you'd make sure that you put on that court judges who you really could trust. And these judges, since they'd be Article III judges, would have lifetime tenure and salary protection. So you're right back where you started. It's a typical District of Washington solution, another agency, some more employment for more federal officials. I think that it is basically wrong, aconstitutional, if not unconstitutional, to seek to overturn Supreme Court decisions by statutory bills to limit the Supreme Court or lower court jurisdiction. If the bills are really going to work, they're unconstitutional. It would mean that Marbury v. Madison can be overturned by a mere jurisdictional statute, and Marbury can't mean that. If you're meaning something less than that, then I don't understand how it's going to overturn any decisions you're unhappy with.
yes, sir.
There's a recent case that makes me wonder if the horse has already left the barn. Nevin versus California Coastal Commission.
Can't hear.
Nevin versus California Coastal Commission is a case that makes...
Nolan?
Nolan, I'm sorry, correct. It's been a few weeks since I read it, but it seemed to me that Justice Scalia, who wrote the opinion, involved California making a regulatory, effectively taking an easement on a piece of beach property. And Justice Scalia said, is an easement one of those sticks in a bundle of rights we call property? Answer, yes. Was it taken with this inverse condemnation? Yes. Therefore must be compensated for. And a dissent by Mr. Justice Brennan relied on a lot of previous cases as precedent. Justice Scalia had sort of gone straight to the constitutional, very plain meaning sense. In the discussion tonight, no one has mentioned that body of law calls previous cases stare decisis. And given the ability to sort of say, well, I'm going to go straight to the Constitution to justify this ruling, or I can go to previous cases, which are previous expositions of what the Constitution really said, then you leave a little bit of a great deal of room to be characterized as an activist and activist. Who was an activist in that case? Justice Scalia or Justice Brennan, who in previous cases where sort of conservative versus liberal debate had taken place, the liberals were accused of sort of going to a simplistic, direct language of the Constitution, and conservatives were left trying to dredge up a lot of precedent.
Precedent's relevant, sure.
If a judge has the flexibility to go to either, which of course he does, then to address it in these terms is perhaps a little late, isn't it?
Well, I may read the case a little differently than you do. I think that we build on the prior law. We don't start each day afresh. We take.
Gee, I cited a couple of cases in that opinion.
When I read the
All entitled Pennsylvania Coal.
Yeah. Well, I thought the court dealt with the cases there, and there was a logical principle that they were supporting that seemed to be supported in the case law. I think it's perfectly fine for there'll always be disputes on the court or commentators looking at the court as to whether or not they've read the precedents too narrowly or too broadly. But at least we're talking about the same baseline, and at least in our panel discussion, I thought the thrust was, should we get away from that baseline and talk about something else? And there's plenty of dispute right within this baseline, right within our written Constitution to keep us all busy for a long time, that I think it is dangerous and ultimately self-defeating to be urging the court to go off to the unwritten Constitution.
I see your point. The question is an opposite.
Well, I wouldn't say it's an opposite. Just my view of that'd be my response.
One of the things I was busy doing when you were raising your question was writing down the answers, because those of us who believe there are such want to know what property is, and I'm glad Justice Scalia has some. I was scribbling them down. The question you raise about precedent can be raised in either of two contexts. You can either ask it the way you seem to ask it, which is it, the text or what the Supreme Court has written? I think the answer to that is easy in terms of what is our Constitution. It's the text. That doesn't mean precedent doesn't have an effect. It's one of the things that certainly go into a legitimate theory of interpretation of the text. And there, within the theory of interpretation, there's a nice debate about what the effect of precedent is. Does it have less effect in constitutional cases because the issues are so momentous and the rule of law values somewhat diminished in their force? Or does it have the same effect as it ought to have in other kinds of cases? A nice debate, but I don't think anyone's going to leave it out.
I must say, I think we're in danger of getting all mixed up here and mixing up issues. I do think that case is a case that is methodologically rather unproblematic. That is, it is a case where the relevant materials, which include the text and its history and its subsequent interpretation, and the scholarly commentary on it, led to perfectly legitimate and genuine ambiguities on what the correct solution is. And it's not an example, I don't think it's a good example of the problem of the unwritten Constitution. It seems to me, and a lot of the questions, it seemed to me, that is, I think it's a mistake to take an opinion you don't agree with and say it's an example in which the court invented an unwritten Constitution. I think we should understand why the problem of the unwritten Constitution is a problem. It is a genuinely problematic question. And of course, it's exactly the question that the anti-federalists who insisted that there be a Ninth Amendment had at their, that they were thinking about. They were worried about the point that if you list 9 rights, they had 2 worries about that. One is that a listing of 9 rights or 10 rights or 11 rights would imply that others don't exist, that it would therefore narrow the scheme of ordered liberty, and that was a genuine worry. And their other worry was that listing rights would imply that rights came from the government, that the Constitution was granting rights, and that's why the Ninth Amendment uses the term are retained by the people. It seems to me the problematic question about an unwritten Constitution would arise if one played a mind game. Suppose the Anti-Federalists had won and we didn't have a Bill of Rights. There were absolutely no Bill of Rights. The Constitution was unamended. And 10 years later, the Congress passes a statute that censors newspapers or censors speech. What would we think about the situation at that point? Would we think that that was constitutionally unproblematic at that point? Would we think that that was constitutionally a non-issue, whether what Congress did was within the spirit of the Constitution? And then we would have another question of whether the courts would have a jurisdiction to invent a natural law or a basic scheme of ordered liberty proposition, that that's something that the Congress has no power to do in the absence of a Bill of Rights. That seems to me to be the problematic issue.
I think that that's an excellent comment on which to terminate this. I'm sorry for those who still have questions, but we've gone somewhat over our time already. There is another ceremony yet to occur, plus a reception afterwards. I thank the panelists for their comments and